That's worse. 3.5 hour hearing. I guess.
Next month, we're gonna be talking about this benchmark report that between this is from the Minnesota Funding or Minnesota Chamber.
I haven't like seen that. I'm sure.
Yeah.
Gonna do.
Oh,
Oh, you have our. Oh, that'd be great.
Yeah, that's what I do.
Thank you very much. And I. Probably because of the screen.
Yeah.
So. And then I have to figure out how to, make sure I can share my screen.
Yeah, just think after 3 years of this.
I know you think we
Boy, I just gotta ask this.
I have not even looked at any of the emails. So. Look.
They updated the app, so the things I've done, I use. Make sure it has.
I don't know. After this meeting, no.
Yeah, no.
Good. Good. How about you?
That show was super good.
Yep.
Less snow than I know. Yes, it's not dry at all. Yeah. There you go.
Say no to everything that got passed. They hire people like.
Yeah. Yeah.
So I'm always looking for areas of workforce coverage area like.
I think one of the first one, I mean, currently you should have this. Go on the DLR website. Oh, I noticed.
Yeah.
Guess I gotta.
Yeah.
There's been lots of stuff.
Yeah.
Yeah, but, yeah. How about yours?
What is?
Okay.
But then the other.
Yeah. I locked it off. Yes, yeah, I don't, you know.
Okay, you're enough.
Oh,
I.
I keep telling,
Oh.
Yeah.
You just
He's the kid.
Oh, yeah.
Please find out.
I'm trying to get my soul out, make sure.
Rochester for his.
Yeah.
Thyroid. I don't. Anyway, they have cancellation
Right around there.
this morning or today. I guess he didn't say this morning. He could either do it tomorrow, Tuesday, or it would be the end of January. to the middle of February. And he's already met his deductible this year, and he would have to pay the full deductible again if he waited till January. It's $4,600.
So is that replacing his surgery from the 20th?
My surgery's on the 20th.
Oh,
He was gonna do something. He was hoping to get it done between Christmas and New Year's. So then both of us would go. Now, we won't both be gone. They said 3 days. He doesn't know if that's too soon. Or Wednesday, Thursday, Friday that he has to be out. So he might be back Friday. Okay. Schedule today. 10 o'clock, 12 o'clock. 8 o'clock is a meeting about voice of business employment law. And I think somewhere I read, if I remember right, they're gonna cover that thing.
Okay.
So we're gonna listen to that at 8. And at
I don't. Oh my God, this is 7 a.m. Oh,
There needs to be more room.
I'm trying to.
Let's just.
I've never been.
Doorway.
See.
How about yours? Right. I think that's kind of a little out of it. A lot of it. If you ask any questions, I'll answer them, but.
Well, then you start.
Doing all right. See, there you go.
Yeah. Thanks for being in the room, Sean, in case I need some technical support here.
I was just gonna get you started.
Hi, everybody. How are you? Are you excited? Isn't that great?
The excitement is palpable.
All these people can see you out.
Yeah. I'm not, this one, like lawyers cover up. So I'm. I don't. Only something like the same. Yeah.
Preservation.
I'm gonna get yelled at about it.
Well, I'll take some.
Well, that's true, I'll say,
Defer to.
Representative. Miller over there.
Actually, it'll be really interesting.
I really do love this. How much you making you try that? Change.
Well, ESSC, I can't it all, but, for if we leave, I think ourselves 26. That's my goal.
Yeah.
I'm going around. The biggest one that people are the most concerned about is what's gonna happen with school districts. The school districts, our teachers are for these benefits. Basically take about 1.5% of what they have because it's gonna be such a needed.
Medium communication.
I know, what?
Bigger.
Kick it off. Good morning, everyone. Welcome to the Voice of Business Committee meeting. A lot of faces that I haven't seen before. We want to do introductions. We'll just go ahead and kick things off.
But I think we have a lot to hear from you.
All right. So one topic today, and it's very important. Obviously, it's most of you. So we'll go ahead and turn things over to Adam, who's going to cover the new labor laws that are going into effect here shortly. So, Adam, I'll let you go ahead.
All right, well, thanks, Joe. I'd like to thank the Helena's Chamber for organizing this and inviting me to present on this. It was I guess you could say a busy session this last year at the legislature, especially as it pertains to businesses and in particular employment. So I am going to cover many of the changes that were passed. I'm going to spend the majority of the time the employee safe and sick leave that was passed. I'm going to cover very briefly some of the other topics first. Feel free to, if you're in person, anyway, it's easy for you to see you, to raise your hand if you have any questions. It should be pretty informal. So we'll start with the paid leave law. And this is the one that's not going to go into effect until 2026.
Just
Second, for those of you online, can you see this slides? See the screen? Anyone?
Yes, we can see them.
Thank you. Yep, sorry. Guys, do you know how to tell us if the screen's up?
I know. Are you on? What are you doing?
Yeah, but,
So. Oh. Down to the participants.
Yeah, I go up to.
They were since 20.
okay, that doesn't show my screen, that's why my.
Oh, that.
These bases.
It's
a case study.
The last one that was friends.
So, what do you, okay, so tell me what you would like to have.
There are people waiting to get in.
I gotta go.
But I don't see the top. Like they do. It does. Thank you. Good morning. So, let's see.
Uber to me.
You need to.
Yeah.
Technology that. So as you see, we begin, shout out, please.
All right, well, like I was saying, this is the paid leave law that begins January 2026. So just kind of briefly, the way I understand it, the employee safe and sick leave is more short term, and this will be more long term leave. And it's similar to how unemployment is operated right now. So there's a contribution by the employer and the employee into this program, 0.35% of the wages, and there are wage guidelines before somebody would qualify. And employers with 30 employees or less would actually pay less, and the rest would be covered by the state. So, you know, some of the questions I get now is, okay, you know, this doesn't come into effect until 2026. What am I supposed to be doing in the meantime? You know, assuming this does become law in 2026, one thing the employers can look at is, I don't know if you provide disability insurance for your employees, short or long term, you may want to look at whether that's necessary after this time period begins. And potentially want to look at, if you're drafting new policies or employee handbooks that are going to be effective in 2026, you'll want to include some of this language as well. You know, we're still a couple years away. A lot of it could change in the meantime. I don't know if there is additional information that you have. But.
There's just a couple of different things. In August, this was finally put through by a third party to kind of audit how much this was going to cost. And we were finally looking at how much it was going to cost our school districts because the teachers unions asked to be included into this. And so unfunded, this is going to cost our school districts about $76 million. And then on top of that, in October, as they were going through this, the premium of 0.7 we found is unsustainable. And so before it's even been enacted, which is again in a couple of years, they're finding that that is not appropriate, that it was actually off by $623 million. And so it's actually going to be 0.78. Proponents of this are saying, oh, look, we're only off by a point, you know, little bit. I'm like, I don't know, if you are off by $623 million, you'd probably not do well in your business. And so this will be going up in DOL. The commissioner of deed has carte blanche authority to raise this if he needs to. If it's not self-sustaining, basically, by the amount of taxes that you're paying in through payroll tax, he will increase that. As of right now, in the bill, that can only be increased by 1.2%. So that's where that threshold is, but from 0.7 to 1.2 is pretty drastic, especially if you're looking at, we did see an error of from 0.7 to 0.78, and that's $623 million. So those are the things right now that have been changed. And so I haven't looked very much at the employees paying less. We were told everyone's paying everything, so, which is good. Maybe they wouldn't change some things, so.
Again, with any law that doesn't take effect for 2 years, a lot could be subject to change, but as of now, this is the information we have to go on.
And if there's anyone online who is part of the school districts can, when they're, or any type of union, from what I understand, if they are a part of this, they can actually negotiate a part of their contract that the employer pays all of this instead of dividing that between employer and employee.
Okay, who's our Zoom expert?
What if you stop share and then if you reshare it, it
Yeah.
might reset it, just give it a.
So the red button is a stop share. Yeah, but
The problem is she can't see it on her screen. She can only see what's up there.
It's on
No.
the extended screen.
Oh, just do that.
Do you want to do a duplicate?
Do you want to do a duplicate?
Yeah, whatever would work, yeah.
Now you don't have. So.
Wait.
Start sharing.
Poor Lane.
Screen 2, so you want that to be screen 1.
So Tara, you know.
Come on over, Tara.
So
Does it show you both screens right now? You can click and drag it to the other side.
So if I drag this.
She doesn't have.
You know what you can do? Hold the Windows key, the one with the 4 squares on the bottom.
She's like, go over it. Go over it. Please. I got you.
Are you able to share everything?
Yeah.
Lane has no secrets.
Well, let's do a duplicate.
The secrets I have are.
It's
all
going
your-
to do
Well, that's perfect.
both. So you have to pick. This is the one you're sharing.
Can employers push that all on employees, or is that not? Can't do that.
That's from what I understand. The only one that's able to kind of update all of that is when you have it. You need, at least
This change.
there were lots of discussions on our union members, many of them who wanted to not be included in this because of the fact that they negotiate for their benefits. The teachers union was pretty, and so like some of our trade unions had actually advocated to not be a part of this, so they could negotiate their own benefits. Whereas our education unions begged to be a part of it. So I don't, because it was kind of passed without anyone really knowing what was going on. There still could be a lot of different things.
Can I ask a quick question?
Yeah.
Are you guys gonna be providing any kind of a summary of all this, or do we need to take notes as
Well,
quickly?
you don't have to take notes. Anybody that wants the slides, I'd be happy to provide them.
Thank you.
So just email me and ask for them.
Also, I'll say for the e-blast tomorrow, we'll be doing a summary post based on what you guys are talking about today, so people pull from the audio. So speak loud and clearly.
Sure. All right. The next one is the unpaid parental leave. Basically, the big change here is it used to not cover all employers. Now the language is it covers an employer with 1 employee or more. So, which by definition is all employers, basically. So just 12 weeks of unpaid parental leave is required, covers pregnancy, birth, or adoption. Also up to 16 hours for attendance at school conferences or school activities. Another somewhat big one is the pregnant nursing mothers protections. This was also primarily expanded to cover all employers. Must provide reasonable break times each day. The employee needs to express milk. Break times can run concurrently with all the current break times. Employer can't reduce compensation for a nursing mother that needs to use this. There's a list of reasonable accommodations that are listed in the statute that are on the third bullet point, primarily longer breaks, different times of breaks, more frequent restroom use. Another change that came about was this is no longer limited to the first 12 months after the birth of a child. They can extend past the first 12 months of a child's life if there's still a need to express milk after the first 12 months. And then another change was it went from may to must, then employer allow an employee breaks to express milk under this new pregnant nursing mothers law. All right. Okay. So, and then kind of a summary of the other changes. Race is now as a protected class from discrimination, includes traits associated with race, including hair texture, hairstyle. What should have been on the slide also included in this as a protected class is gender identity is now included as part of a sexual orientation class. Employers are now prohibited from inquiring into and requiring disclosure of the pay history of an employee. Particularly, this happens during an interview process. Employers can obtain this information and base decisions on pay history if they learn the information by other means, but they can't require an employee to provide that information. The employer can still ask an employee what their salary expectations are. They just can't force them to divulge what they've been paid in the past.
Still ask, but no requirement, right?
I would say don't ask them. Because if you're sitting in an interview and you say, you don't have to tell me this, but I'd like to know what it's going to come across as you're requiring it. So, the right of employees to be absent for voting purposes has been expanded for early voting. Before it was just the election day. Non-compete agreements have largely been deemed unenforceable. The date is wrong on this slide. It actually took effect July 1st instead of August 1st. The only real limited situation where it still does apply is if you sell your business to somebody, you can have an enforceable non-compete. But for employees, that non-compete agreement is going to be largely unenforceable if entered into after July 1st, 2023. There's also a prohibition now of an employer from taking adverse action against an employee if the employee declines to participate or receive information about religious or political matters. There is also, as I think a lot of us are aware, changes to the cannabis laws in the state of Minnesota. In the employment context, the law does state you cannot require testing for cannabis prior to giving somebody a job. You can't discipline an employee for off-duty, off-use of cannabis. Now, there are exceptions to that if you're in certain industries that are safety sensitive, or if you need to do those things to comply with federal laws, those restrictions won't apply to you. But generally, otherwise, you can't test for cannabis as a condition of employment.
I have a question.
Yeah.
So if you have a safety sensitive position, do you have wordage that we can put in our handbook because we don't want to be liable for that?
Yeah, essentially, I do have some examples. Yeah, I mean, Yeah, I mean, you have to be sure it is safety sensitive. So it basically, if you have drivers, if you have people operating heavy machinery, I think that's pretty straightforward. Police officers, that sort of thing. Yeah, I mean, whatever you have, I don't know if you have anything now, but if you can, if it's clear that it is a safety sensitive position, you know, I'm comfortable with you having that language in there. You'd probably want to kind of suss that out further with, you know, an attorney or an HR representative or something like that, just to make sure that you're in compliance. Yeah, if it is a safety sensitive position, I'm comfortable with having that. Yeah, that's part of your policy. All right, I think that's all we have. So that was everything except the employee sick leave. So this will be the main portion of the presentation. Yeah.
The safety thing, that could apply to almost every employee because you're handling different things. And, you know what I'm saying?
Potentially.
Sound fairly broad, you know.
It is.
Is the employer interpretation of safety, or is there something written down saying this is safety?
I'm not aware of something in a statute or otherwise that lists every possible position that could be safety sensitive. One way to think about it would be, think about it the same as alcohol. So, you know, it would be important for you to test or require somebody abstain from alcohol. You think about that as the same as cannabis. It may be one way to look at it. You know, it's very dependent on what the job is. I agree. And yeah, you can make an argument that somebody working in an office potentially could be a safety sensitive position. I don't think those are intended to be covered. It's more of if you're dangerous to other people, if you're under the influence of cannabis or a habitual user. So to me, it's kind of a gray area.
If you're working with the public, it's obvious to be a safety issue.
Yeah, and that might even depend on what you're doing with the public too. Like I said, if you're going home at 5 o'clock and using cannabis, you know, is that affecting your ability to put people at risk the next day? You know, that sort of thing. So it's something that you'll want to look at probably more carefully if you're not sure whether your position that you hire for is a safety sensitive position under the meaning of this law.
Well, all you gotta do is put in your handbook, this is a safety position.
Yes, but you need to be correct. You can't just say it and make it be, you know. So,
okay.
Yeah.
But then they better start specifying them.
Well, yeah, more guidance would be very helpful. I agree. So
I think we need to press on here.
okay, yeah, we'll keep going. So this is the main portion of the presentation, because this is going to be what is affecting employers the most in the short term, and potentially in the long term as well. So that's the employee sick and safe leave. So as of today, the employers are not required to provide PTO or time off. And the employer is free to define when it provides time off and how it's calculated, how it's accrued. And all those are examples of what employers are currently allowed to do, including determining whether PTO is paid out at termination. And then just some general rules. For every employment law I can think of, if your policy is not the same as the law, but your policy is more friendly to the employee, follow your policy. If the law is more friendly to the employee, you have to adjust your policy to conform with the law. And the failing to comply with the law in this regard would be the same as not paying out wages. There would be penalties, etc. The example on the board is if it is your policy to pay out PTO at termination, you have to continue to do that, because unpaid PTO, not doing that is the same as not paying wages. You would be liable for that plus penalties. So the new law that goes into effect on January 1st the employees must start accruing earned sick and save time. The eligible employee must work at least 80 hours per year for an employer in Minnesota. It does not apply to independent contractors, federal employees, or elected officials. Temporary and part-time employees are eligible for this. And another exception is building and construction industry employees who are represented by a labor organization. If that is part of the contract that the employee sick and safe time leave time is waived.
Can I ask you a question about independent contractors?
Mhm.
So can I just say Patty's an independent contractor, or does she actually have to have a business that says Patty's helping hands?
Sure. Well, you don't have to have a business. I can hire anybody off the street and as an independent contractor. Now, that's a different kind of area to determine whether somebody is actually an independent contractor or an employee. You have to look at whether the employer controls the work, controls the hours, and that's a separate analysis. So
Okay.
if that particular person is an independent contractor, they're 1099, they're not W-2, they would not be required to accrue the hours for employee sick leave. So that is who qualifies as an employee for that. Now, this is how it is accrued. 1 hour of sick and safe leave for each 30 hours worked, up to 48 hours per year. Unless, of course, you know, the employer agrees to pay a higher amount, we're always going to default to the more friendly policy to the employee. Now, the term year can mean whatever you use in your business as a year. So it could be a tax year, fiscal year, even the employee's anniversary year. You can do that now. You're probably going to want one consistent time frame for all your employees if you have more than one employee, because it's going to be a mess to try to calculate this and keep track of this. But you can use any version of a year you would like, but the employee has to start accruing on January 1st, 2024, whatever you use. The accrual started first day the employee starts employment. It does not include that you can't exclude a probationary period from accruing the hours. The ESST, when taken, is paid out at the employee's current rate. So if your employee earned that hour, well, they made $15 an hour, but they got a raise in the meantime, and then they took that hour they earned while they're making $15 an hour, they get their current rate at the time. So if they got the raise, they get the higher rate paid out to them. The ESST does carry over from year to year up to 80 hours. So it does roll over up to a maximum of 80 hours. You can't use it or lose it. They get that rollover. You do not have to pay it out if it is not your policy to pay out earned or PTO or in this case ESST if the employee is terminated.
Question?
Yep.
Is it just on regular paid hours, or is it on regular paid hours and overtime?
It will include overtime for a number of hours the employee works. So if they, this is not an exempt employee, and we're going to get to that in a little bit later, but so you have an employee that worked 8 hours, all 48 hours that week would count towards their sick time.
So it doesn't matter if it's accrued or if it's given in one lump sum, whether or not you pay it out.
And I'll get to that later. There's certain things you can do so you don't have to keep track of it. One is just to give it front loaded, and then, or you could give them 80 hours a year basically, and then you don't have to worry about it because that's the maximum they can roll over. To start with, you can front load them with the 40 hours that they would have earned anyway. But there'll be some examples later on that you can use to help with the tracking if you don't want to have to do that.
You'd mentioned that you thought that doing them all at one time, starting like, let's say January, because you gotta do all your main employees January. But if you add somebody in August and you have that as every year at January, you have to pay them the 48 hours from August to the end of the year, or just his amount per month?
Well, so they accrue at the number of
The
hours.
whole thing,
Both top and bottom pins are slide. And then. it
the
makes-
pins on the cylinder.
The cylinder.
Okay. that's all right.
I mean,
He ran the thing yesterday afternoon. He did say,
turn over and actually
no.
used it. Like I tested it before.
Isn't that fun? Is everybody having fun? We provide entertainment and education.
So to answer your question, so if you're on a calendar year basis, you're gonna say that the employees are gonna accrue over a calendar year, we're gonna roll it over starting January 1st. So if you have an employee that starts August 1st, you can choose to front load them for that year. For the remainder of the year, or they can just start accruing starting that August 1st as well.
So you wouldn't have to pay the full 48 hours for that particular employee for that year.
No, you have to give them 1 hour for every.
Yeah,
Right.
they earn 1 hour for every 30 hours. They worked. Yeah. What's the question?
Does it have to be sick time? For example, if an employee gives out 3 to 4 weeks of straight PTO, is that good enough?
You can combine this with your current policy. And in fact, I encourage you to do that. So now with your pay stubs, you should be having, okay, this is how much vacation time you've used this period. This is the remaining vacation time you have left. Now, if you have a more generous or equally generous policy regarding sick leave, put in that portion of your pay stub that this includes employee sick and safe leave time. So it can run concurrently, in other words, at the same as your PTO. You don't have to, this isn't extra if your current policy is already equally or more generous than the law.
You still separate it out of the pay stub?
I wouldn't, no, you wouldn't. You would just say that's inclusive. So as long as, so this law basically is for employers that do not provide some or all of their employees with leave. Or do not provide leave as generous as this law is. So, yep.
One more question. Would substitute teachers qualify for this leave? If a sub works 10 days at 8 hours, how would that work?
Well, if the substitute teacher is not an independent contractor, it would apply. Right. So you would just, so 10 days at 8 hours. Example, so they would have 2 hours based on that because that'd be 60 hours, right? My math is right.
Yeah.
So, yeah, so that they would earn still based on that. Brenda?
Back to the PTO, if we currently do not have PTO, can we implement a PTO starting January 1st in our handbook and
Correct.
going forward if it's?
Yep, if it's at least as generous as this or more, then yeah. Yep,
Okay.
that would be fine. And like I said, just on the pay stubs and the policy say this is inclusive of Minnesota employees that can safe leave. There's no confusion that, oh, I get to take all my PTO and then I also have this additional state mandated leave. You do not have to stack them.
But your PTO has to comply with all of the
Correct.
same.
Correct.
And the employee can use it as vacation or as sick leave.
Yep, and we'll get to the reasons. Here we go. That's the next slide. The reasons they could take their sick and safely. So the employee for their own mental or physical illness treatment or preventive care, or a family member under those same categories. The safe leave portion is if there is domestic abuse, sexual assault, or stalking, they can take it there. Closure of the workplace due to weather or public emergency, which would be COVID in recent years. Closure of the school or daycare facility due to weather or public emergency, or when determined by the health authority.
I just paused for a
Yep.
second. Family members.
Yeah,
It's like, can we talk about
that's
that?
the next slide.
Okay, good.
Yep.
Okay, just wait until you see this.
Yeah.
Yeah, it's pretty much
So-
anyone you know.
Yeah.
Can you be my family member?
Yeah, today, yes.
So, family member.
Sorry,
Yeah,
I didn't mean
no,
to
that's-
jump the gun. I
that's-
just know this is a big deal.
That's fine. So, this is 2 slides. What defines a
For what it's
family member?
What is that for?
So anybody that you would actually, when you think of family member, is included, obviously. Up to, parents, grandchildren, spouse, siblings, etc. Going.
I mean, just go back one slide, Elaine, real quick. The part here, or whom the employee stands in place of a parent. All right, so if you have a person that you consider is close enough to be, you know, I'm a sub mommy to a person, that can count apparently. You know, I was very close to some of my friends and they called my mom. In this new law, that could technically count. And so those are the things that you want to be very defined when you're talking about this, because that's not very well defined.
Basically, if they say, you
You know,
agree
you
with
count
them,
as my grandma, right? Or you
are-
count as my mom or something like that. Those are the things that I don't believe were very well defined in this law.
An example I've heard of too is I had a neighbor growing up.
Yep.
And they've always, you know, we've been always very close. And this neighbor's gotten older and I need to take care of them, but they've always been like a parent to me. That would be included.
But basically, you can't ask what it's for.
There's no
because
proof.
You can't,
Well, that would,
right, I mean.
you can, but
You can, but.
the guidance so far is, do you really want to know? And. You know, so there now, I don't know, you know, with your sick, if you have sick leave right now, how much documentation do you actually
I'm not
require?
gonna go and try and investigate this.
Right. Right,
So it's just take it.
right.
Well, and the reality is that if you combine it with your PTO, it doesn't matter. I mean, if they wanna take 2 weeks of vacation,
Mhm.
when they come and they're sick on the, 81st hour, that's unpaid. So
Correct.
it doesn't, I mean, all of these regulations from family members don't really matter because you're considering, for most employees who already offer PTO, you're already considering what it is.
And a lot of this doesn't matter as much or significantly as much if you already offer PTO.
At least 48 hours.
Right, it's at really 80 hours a year.
Oh, right.
What if you have somebody, an employee that you know is abusing it, burns up their time, but is still trying to take time off after that? I mean, is there repercussions? Can you-
Yeah, it depends on how you know they're abusing it. You know, they say I'm sick with the flu this week, and then you see them at Valley Fair, or, you know, something like that, you know. Same as probably what you have now as far as sick leave, you know, if you're gonna tell me you're sick, you should be sick,
But if they use their 80 hours,
And it's just PTO.
then it's,
Yeah, then you just don't pay them after.
you don't pay them after that, so
Right.
it's basically, if you wanna
yeah,
Take 2
cheat the
weeks off.
system,
January 1st to the 14th, there's gonna be nobody working.
right, right.
and we've probably all had experience with employees that do that, so. And the one thing I wanna, so, the second.
That's one, sorry.
No, that's fine.
Alright.
So anyway, so the list continues. And then the last bullet point too. So if nobody falls into any of the other categories, you still get to designate one person annually that it applies to. So bottom line is, this is gonna apply to anybody that the employee knows. It's probably not gonna be worth time and effort to spend a whole lot of time and effort to determine whether this person is eligible to take the sick leave, is my thought. Yeah.
The last bullet,
Yep.
individual. Could it be a pet?
I'm not lying.
My understanding, individual means person.
It should be a pet though, because like us that don't have kids, like
Yeah,
everybody at work gets extra time off for kids and we don't.
yeah.
How to get on that?
Okay, I'm on it right now. Okay, so I'm writing it down. Pet question mark?
And, you know, employers can't restrict who is a family member, if they qualify, you know, that, or who their annual designated person is, and they can't retaliate against somebody that does this. So when the employee wants to use it, does not have to specifically ask for it. You know, say I'm using my ESST this day, is if they have it available, they get to use it. The employer can require up to 7 days advance notice for things like if the employee knows they have a doctor's appointment, you know, next month. So potentially, and this is up to you whether you want to go down this road. If you find out the employee knew about this appointment, a month ago and then notified you 2 days early, you could potentially deny the use of the ESST for that appointment because they did not notify you. You can require 7 days advance notice. However, you can't deny ESST if the employee recently did not have 7 days advance notice of the need to use it. For example, they wake up with a sick kid that day. And you can require if the employee is on FMLA, if that applies to your business, that it be used with that FMLA. So you can be required to burn through your ESST while you're on FMLA as well. So it doesn't stack, in other words, on top of your FMLA.
So is there, I'm sorry.
Yep.
Just a question that came to mind. When you said it rolls over, is there any cap on how much?
80 hours.
But in terms of if they don't use it at 80 hours in that year,
Mhm.
and so they continue to accrue.
They start with 80 hours the next year.
So then do they get 160?
They start with 80 hours maximum.
Okay, okay, so it always
first
caps at 80.
Right.
So you can give up to 48 the first year, roll that over till you get to 80, correct?
Yeah. So if you're on a calendar year basis, right now, you could just start every employee out with 48 hours, January 1st. And then January 1st, 2025, start every employee out, the same employees out with 80 hours. And then you don't really have to track it because they're at their maximums. Each.
If an employer allows a certain amount of carryover now in PTO, but forces usage by a certain date, will that have to change? So at that point in time,
What's more friendly to?
What if you chose for like certain employees to front load it, but other employees that might be part-time or on call to accrue it? You don't have to do one size.
No, it's just more work for you.
Right.
As long as they're accruing 1 hour for every 30 hours they work, minimum. Or they're given the maximum under the.
So you could do, like, we've got road construction truck drivers that get laid off for 4 or 5 months out of the year. Then we have full-time who run. So we could do accrual for those seasonal and front load for the full-time.
Yep, as long as they meet the minimum under the.
But wasn't there a stipulation about if you did this much, you had to pay it out at the end of the year? If you didn't front load it?
There's no requirement to pay it out, unless you already have that policy that it is paid out, your PTO.
So no matter if you front load it or you accrue it,
Right,
if our policy says we don't pay out PTO.
correct. You don't have to pay out ESST.
For the usage of that. So let's say I earn 2 hours, but now like our employees, they don't work an 8-hour day necessarily. How do you justify, okay, this person has 2 hours. They use that 2 hours, they're only gonna get paid, if they're gone the whole day, they're only gonna get paid for the 2 hours.
Correct. Yep.
No matter what.
Correct. Yeah.
So if you lay employees off,
Mhm.
can you force them to use the ESST before they leave?
No, you can't require them to take the SST, but they would want to because they don't get paid out, right? Unless they do, under your policy, I guess.
So when you go into layoff, there's no, does that, so if our seasonal, right? So if when they come back to work, do they start where they ended or do you have over?
In a later slide, we talk about laid off employees. I don't remember the top of my head, but it does come up later.
Isn't it after like 180 days or
Yep,
something?
I think that's right. Yep. Yeah, it's,
But now, if you lay an employee off, they go on unemployment, there's that, what is it, a 1 week wait period that they don't get paid for? Can they use this for that 1 week and then start their
they could, but
unemployment?
it would still, so they're technically still employed if they're using their ESST, right?
Okay, right,
So,
I suppose.
yeah.
I understand they can designate one person each year and related to this, do they have to disclose who this person is?
They have to designate who that person is annually. But I don't know who would fall into the category that it's a friend, I guess. That's not like a parent to you.
So would they have to do that up front?
Yeah.
January 1st, say I'm gonna designate, they can't wait until
Yeah,
January.
it's a good question. I don't know if I know the answer to that, but yeah, when you have to set the deadline.
Can the employer require an employee to use ESFT, assuming they have time available when they tell you of an event that qualifies or is optional based on, oops. Is it optional? Okay.
Yeah, so if they have a school program and say, I just don't wanna get paid, but the employer says, no, you're using some PTO or ESS.
You can require them to take it.
Okay.
You know, generally, I know my place of business, if you don't have any PTO, you don't automatically get to take unlimited unpaid time off either. It's an employee discipline issue at that point.
One of the main things about this is if you currently have a policy requesting approving something ahead of time, this law makes that hard. Anyone can have a mental, say the morning after the Super Bowl. There's so much you can do about it as an employer.
Correct, especially if you're a Vikings fan.
We worried about going to the Super Bowl.
Yeah, well, another one went by, we didn't make it.
If current policy pays out vacation, does this company also have to pay out ESST or can it be separate?
My understanding is if your policy pays out earned leave, the ESST is earned leave and it needs to be paid out.
So we have PTO and sick.
Yeah.
So, and they're going to give us ESST. Ridiculous.
Yeah.
But, so we don't get paid out sick, but we get paid out
Yeah.
vacation.
I would put this as sick leave. That would be my inclination.
And what about a salaried employee?
Yep, and that's coming up.
Okay.
I think
So
too far. Yeah.
Okay.
It's good. Real quick. So employer cannot require specific details about the reason or details related to the family member's medical condition. Again, this is going to make it very hard for you to really enforce anybody taking advantage of the program. If there's more than 3 consecutive days, however, you can require documentation. So it's similar to a lot of what employers have already. If you're sick for 3 days, I need a doctor's note, so you can still do that. Then the question is, do you want or need to know the reasons? Do you want to get involved? That's up to you individually. Confidentiality, if the employer, or I'm sorry, if the employee gives you information about their health or health of reasons why they're taking this, keep that information separate from the main personnel file. Yeah, and you can't disclose that unless you're required to by law. So the other responsibilities you're going to have is you must include the total number of hours earned on ESST, accrued and available for use, as well as the number of hours used on their pay stubs. Provide employees with notice on January 1st, 2024, or at the start of employment about their rights under ESST. If you go to the Department of Labor and Industry website, they do have a sheet. And I would recommend downloading the Word document because you can go in, there's portions you're going to need to edit in there. Be careful. The DLI has a habit of using their forms and it's more friendly to the employees than is required. So you don't want to get stuck by agreeing unintentionally with a policy that you don't need to agree to.
It does say it in red. I just went and looked at it.
Yeah.
And the part about like requiring time, letting them know ahead of time. It does tell you that you can change this part.
Okay.
But
yeah.
Yes.
Yeah, be careful. Don't just
Yeah.
take it, say, yeah, oh, it's on the state website. I'm printing it off, giving it to my employees, and that's our policy. You want to be careful and review that carefully. I know when we talked about the wage law, the sheet they had there specified that Minnesota, that overtime starts at 40 hours and actually doesn't. It's required under law at 48 hours. So there's some things like that kind of aren't accurate that you might get stuck with if you don't read that. All right. And this basically just says if you give a payment every 2 weeks or with a pay stub or every week, it should be consistent with that. So general rule of thumb, just include it with your pay stub. As we've talked about quite a bit already, This won't have much an effect if you have a policy already in place that's as or more friendly to the employee. You know, if you meet or exceed, you know, as long as you're following the other rules regarding use of the ESST, you'll be in compliance. Inclusive of ESST, I think I've already mentioned, put that on your pay stubs. So when you list, you know, this is your, if you already have a employer program where it gives them as good or better PTO, put that statement next to their statement of how many hours they've used and accrued and their balance. So it's clear that this is also includes your ESST, what we provide you. Yep. All right, salaried employees. Salaried employees are presumed to work 40 hours a week, and these are exempt employees, so they're not eligible for overtime. If it is clear that for whatever reason they're salaried exempt employees and they work less than 40 hours a week, you can base that on how many hours they actually work. But ESST does not accrue when the employees are not working. So if they're taking time off, you don't have to accrue that ESST on there. And then these are the examples I think we talked about already. Okay, can you just gift your employees 48 hours a year? Yes, you can front load the ESST. And then really what this helps you with is we are record keeping. You don't have to keep track of this and worry about, you know, carryover and that sort of thing. So you may want to use this if it helps you better with your record keeping. And these are some additional options regarding front loading. So you can, you know, give them the 48 hours ESST for immediate use at the start of each year. You can choose, if you don't want to have to roll over ESST, you can choose to pay it out. So if they have 40 hours left at the end of the year, and you don't want to roll it over, you can choose to pay it out to the employee instead of having it roll over, depending on what you prefer. So, and as we talked about, you can front load with the 80 hours as well after the first year. And then, you know, that would be an example where the hours aren't paid out. So, you know, you start them out next year with 80 hours.
How does that work that if they didn't use any time, you pay them out for 48 hours, you have to start them over again at 48 hours? Because they can only
If
incur,
they're front loading, yeah.
because they can only do 80 if you roll it over.
Right. So, you know, your two options to begin with are they can just earn 1 hour for every 30 hours they work. And it's up to you to keep track of that. The other option is just give them those 48 hours at the beginning of the year that they can use immediately if they need to. And then at the end of the year, say they have 40 hours left, you can choose just to pay them out for that 40 hours. So they start at 0 the next year if they're accruing, or 48 if you're front loading. So, you know, whatever you think you want to do as far as payout versus rollover, but they can roll over. So if they have, you know, by 5 years, but you know, they might have a bunch of ESST saved up by the end of the year exceeding 80 hours, but you only have to roll over 80 hours into the next year. What people might start running into is if they have all this ESST in December, they're gonna get a lot of sick days in December if they're over 80 hours, unfortunately, I think. So.
You would just cap it at 80.
You don't need to keep accruing past 80, so that they.
Right, yeah, that's true. You don't need to keep track of that. That's true. Well, yeah, the maximum is 80. You're right, yeah.
But if they have 80 built up, they're gonna take time off to earn.
Yeah, so they're gonna take 1 day and then they're gonna get good at the math eventually, I
They're
think.
gonna start to do Monday
Yeah.
after week.
I just, like, we've had this discussion multiple times. I feel like if you have employees who already take advantage of the system, who already use all their vacation and all of their sick leave, they're just gonna continue that pattern. Like, we have employees who never take vacation, and I feel like when this comes about, they're not gonna care. I mean, I feel like your employees who take advantage are gonna continue to take advantage. Your employees who don't aren't gonna see this and say, oh, well, I'm gonna start taking advantage of the system. I feel like there are just people who do it and people who don't. And, you know, we're
Say if
super,
they need it.
yeah, we're super fortunate that we don't, I mean, out of 40-some employees, most of our employees don't even take vacation. So, you know, I feel like you know, everybody saw this in the beginning and started freaking out that everybody's gonna be off. Now, I do worry about the one that comes in. The next one I do worry about, but this one, I feel like if you already provide vacation and you already have employees who don't use it, I feel like it's not gonna be as big of a deal as everybody thinks it is.
And this is gonna hit hardest on people that primarily employ part-time employees.
Right.
That, you know, generally you don't provide paid time off for part-time employees. So that, yeah, you're right. For you, probably this won't have much of an effect. It's just some additional record keeping or, you know, some, you know, maybe some slight changes to policy on when you can take sick leave, you know, because my neighbor's sick kind of thing. But yeah, you're right.
They're gonna, I mean, if they have vacation or sick, I never ask.
Right.
They just say like, I'm taking off. And I would never, I mean, I don't know how many people have employees that they can replace. But we don't, I would never fight them. I mean, I can't afford to lose employees, so I can't, I'm not gonna, if you tell me your mom's sick or your mom died, and 3 weeks later, your mom died again, like, what? I'm definitely not gonna say anything. I mean, I feel like we're not in a market to fight it.
Yeah.
But
I have a question
Yeah.
on the salaried employees.
Mhm.
In my case, the owner also draws a wage.
Yep.
So is he entitled to,
So,
and how did,
he gets a W-2 at the end of the year.
he gets a, yeah.
Yeah.
1090, yeah.
Yeah.
W-2 at the end of the year.
Yep. He works 40 hours a week. He gets his employee sick and safe.
Is it a W-2 or a 1099?
He gets both. Depending on.
There's that too.
Yeah.
Yeah. And you know, it's been talked about some places where you're the owner, you really have unlimited time
Well,
off,
that's
you know?
just it. It's like, you know.
So,
On your under.
yeah, and that's the next slide. So, yeah.
That's the thought.
Yeah, we talked about what a year is, and basically it can include any version of the year you already have for your business. So
So if you go back to that, his example of, let's say you have 40 hours left at the end of the year, okay, and it rolls over.
Yep.
Now, does the employee just get 40?
No. They can.
Well,
Or is that 48? Because you said he can't go over 80.
right, so if he has 40 hours at the end of the year, and it depends on how you want to handle it, again, you have two options. You can just front load it, so you don't have to keep the records, or you can have it accrued for every 30 hours that employee works. So if they have 40 hours at the end of the year, that rolls over, so they start the next year with 40 hours. If you're front loading, now they could get another 48, but the maximum is 80, so they start with 80 actually.
Right.
But you could also start with 40 hours, and then for every 30 hours they work, they get one additional hour added to that 40 hours. So it depends on how you want to handle it as the employer. If you want to be in charge of keeping track of how they're accruing, or whether you want to front load, you know, that's up to you.
And if you're tying it all in with your vacation and everything, then
Yeah.
they can go over that.
Right, if your
48,
policy,
obviously,
if your policy allows them to go over that already.
If you have full-time employees, week 36, they should have 48 hours.
So you said that there's no cap, I mean, like, my guys can easily put in 70 hours a week. So they're gonna accrue 2 days per week.
2 hours.
2
Or
hours.
yeah, sorry, 2
Probably hope
hours
it's
per
not 2
week.
days.
Sorry.
Here's
So
that
2
48
hours
real quick.
per week. And there's absolutely no cap on overtime.
So, but you have to count every overtime hour as an hour.
Very good.
It's not 1.5.
Yeah, it's not, yeah,
Well,
there's no
right.
penalty.
No, I mean, yeah.
So it's for
But only
every
up to
30
the
hours, so if they
48.
work 40 hours, that 10 hours
No,
rolls to the next week,
Right.
that's,
Yeah.
and it just keeps going until.
Yeah. So again, this is, you can kind of tell this is geared a lot towards part-time employees. Back to the one.
That's why.
And this is what we were talking about, the unlimited PTO policies, so. You could always just reflect they have 80, you know, the owner has 80 hours of employee sick and safe leave on their pay stub. So then you're always in compliance, if there are any record checks by the state or anything like that, but, owners who also work for the business, a lot of times can take whatever time they want off, so I would just always reflect that.
We have a couple of questions to come back to.
Yeah.
If you front load as option 2, employee quits mid-year but used all sick time, can you take back unearned sick time?
No,
40 in the first option, 80 hours in the second. What's the difference in examples? I think you covered that. Super excited for the city to have to track sick leave for part-time lifeguards in the summer. Okay,
Yeah.
okay, this. Yep, that's interesting.
all right, you go. Already answered this question, can you treat salaried employees separately from part-time employees as far as how they accrue versus front loading versus accruing? Yes, as long as you provide what they're entitled to under the law. If you have a more generous accrual policy, stick with that. It's more friendly to the employee. Not paid out when the employee leaves their job. You can choose to do so. If you had an employee that was promoted within your organization or moved to a different position, they don't start over at the SST, it carries over to the new position there. This is the question already came up too, is if an employee is terminated or leaves work, do they get to keep their ESST if they return to your work? And the answer is yes, if they do so within 180 days. They get restoration of everything they had at that point.
A better question regarding like for termination for PTO, or not necessarily termination. Somebody leaves in our policy currently is that we would pay out any PTO. For this ESST, would we have to have that? Because we're not required to pay out the ESST. So if somebody's got 120 hours, they quit, do we pay out, do we subtract 48 hours off that, off the 120? Or
no, so
do that?
if your policy, if they have sick time, unused sick time and they leave, ESST would be included in what needed to be paid out when they
It
leave.
is, okay.
So it has to conform, again, more friendly to the employee, so it has to conform to your. Change of ownership. So if somebody comes in and buys the business, the current employees that are retained, there's no change to their accrued and unused ESST. This is kind of a unique situation, but if there's an employees who are terminated by the original owner and then rehired by the subsequent owner, and then they start working for the subsequent owner within 30 days, they get to keep their ESST. Yeah, and then we already talked about whether this accrues on overtime hours worked, and the answer is yes.
Quick question here. So to clarify, could you give 3 weeks PTO, which is front loaded, but also give ESST, but require earning ESST?
So, I mean, I guess, I don't know if I understand the question, but it can run concurrently. So if you front load 3 weeks, so that would be 120 hours, right? So that's more, that's more generous than ESST. So you would just have ESST running concurrently with those 120 hours. You're more generous than the law, so you're in compliance. And then when they take it, any of those 120 hours, they're also taking their ESST. So yeah, you wouldn't have any problems there.
And if a company was to front load with 80 hours, can an employee earn more past this 80 hours with hours worked?
No, they're not required to, in other words. Sure. So I don't know how many of us have employees that do not work in Minnesota. Perhaps we have some employees that work in Iowa.
Do not live in Minnesota.
Oh, live in Minnesota. Yeah, that's the next slide. So it doesn't matter where they live, basically. If they work for you in Minnesota, they get the Minnesota protections of the Minnesota law and the ESST. Only time worked in Minnesota counts towards that, though. So you have to work in Minnesota in order to qualify. So if you have an employee that works in Iowa for a portion, works for you in Minnesota for another portion, the hours worked in Minnesota count towards the ESST.
An employee ever have more than 80 hours?
They're not required to. They can, obviously, if you want to provide it. So out-of-state employees is what I was thinking we were on. The employer is based out of Minnesota, another state. Those out-of-state employees are not covered by Minnesota's law. However, the laws of the state where that employee actually works would apply. So you want to, if he or she works in Iowa, make sure you're in compliance with Iowa laws. You can give them ESST if you want to, but again, you have to follow employment laws in the state that the employee is actually working. Remote workers. This depends on where they're remoting from. So again, general rule is if they're working in Minnesota, they're protected under the SST laws. If they are not working in Minnesota, the laws of that state should apply. So, you know, commuters, we have people who work in my office that commute in from Iowa. They work at our office here in Austin. So you know, they are protected in the SST. So again, just depends on where they work.
What if they're remote in Iowa?
So if the work is conducted in Iowa,
Then it's in
my
Iowa.
understanding it was they're protected under Iowa, not Minnesota.
Just like the payroll laws, right?
Right. Staffing agency employees, if you hire anybody from a staffing agency, the agency is responsible for paying the SST unless you have a contract with a different arrangement with the staffing agency. So, you know, I'd recommend going to and looking around the Department of Labor and Industry website. They do have information there. They do have a sample notice that you are required to provide to your employees that substantially conforms to that notice beginning January 1st or when a new employee is hired. I think, yeah, that's all.
I have a question. Can we revisit the two examples of 48 hours front loaded and paid out at the end of the year versus 8 hours front loaded and not paid out? Is there a reason for differing hours or just constant?
Yeah, the reason, so yeah, it gets confusing because the most an employee can earn in 1 year is 48 hours. And the most they can ever have, or the most you're required to allow them to have at any time is 80 hours. So when we're talking about the 80-hour example, we're talking about hours that would have rolled over into 2025. So you start out with 48 hours that you can earn that year, and it will roll over until you get to 80 hours, and you're not required to allow them to roll over any more than 80 hours. So that's why we're given the two examples with the two numbers, because starting in 2024, the first year of the new law, the most anybody is required to provide is 48 hours. However, now when we start the rollovers, now we're getting up to the maximum 80 hours. So that's why we're talking about those two numbers.
You don't use it.
So the front loading is just if you don't want to have to keep the records and you want to keep it simple, you may end up giving more employees sick and safe leave time than you're required to, but it may be easier on you. So that's why when we talk about the front loading, that's why we're talking about that for employers' simplicity purposes.
If you pay out the 48 hours at the end of the year, let's say.
Yep.
Then you start all over again.
Correct. You have the option.
So there is no such thing as an 80-hour rollover.
Yeah, there is if you don't do front load. If you don't do front load, if you accrue it. Every 30 hours they make an hour, every 30 hours they make an hour.
So they get up to 48 hours.
In
At
1
the end of the
year.
Roll it forward, keep accruing up to 50.
So even if you paid out the 48 hours, it doesn't start.
No, you can pay it out and then you avoid the rollover.
Yeah.
Yeah.
But you're also risking them taking all 48 and then getting another 48 starting January, which is 96.
Yeah. And then they would lose those extra 16 because you don't have to give them the 96. So, if you want to put the last slide, I'll have my email address on there if you want me to email you the slides. I will do that.
And if you're okay, we'll put a link to the slides.
Oh, even better. Then yeah, I will.
Read the e-blast, people.
Let's give Adam a background. Trying to decipher this is really hard. And let's also acknowledge the great work that Patty does for us. And we know
I
that
couldn't stop it, I'm
she's
sorry.
fighting for us. And so you know, we just need to really work together to try to keep telling the story about how the decisions are impacting local businesses. And hopefully the people on the other side of the room will hear the message and understand, because when I think about a really small business with 1 or 2 employees facing all of this, it's pretty daunting. But thank you for your continued engagement. And we are about helping you figure out how to work around and make these things work. And appreciate Joe as the chairman of our committee. And we have, I think, a pretty good program for next month. So we'll hope you'll join us January 9th. We're not going to come in on the 2nd because we think maybe you guys won't be ready for it. It'll still be.
Kind of like that Super Bowl Monday.
But in next month, what we're going to talk about is there's a business benchmarks that the Minnesota Chamber has put out, and talking about the ranking of Minnesota in a lot of different areas, and helping to look at how maybe we can provide information to our elected officials to make changes so that we become more competitive in terms of business. So here's a couple of this.
And I would say, I know you have to leave, but what I would say is that obviously right now I can't take this law and just say, go away. And I can't take paid family leave right now and say, go away. But I might be able to do what I kept talking about with Elaine before, was how do I make this suck less? Sorry, I was a high school teacher for a long time. How do I make this hurt less? I can't make it go away, but how can I make it hurt less? And so if there's specific places or specific ways for right now that I'm able to change or amend or to put in a little, something on it. For example, one of the things we've talked about is how can we use the federal guidelines of what a small business is, instead of it actually being every single business that, under the sun. How can I use the federal guidelines so that you guys have a little bit of relief? So that's one way.
Well, thank you for coming and participating, and we'll see you soon.
I think that's you. And so are you concerned about the policy, right?
Yeah.
What? Okay.
They use up for you. Not just.
And as I said, we were like, hey, you guys pushing for your benefits.
My thing is, if you don't.
They love hard. How dare you? Blah, blah, blah. And you're like,
I mean, it's up to you.
so that's been a really difficult thing.
Yeah, so.
Well, it depends on if your people are gonna abuse it too.
So 5 years that I've been working, I have to go back and trying to, that we were trying.
Oh, it doesn't, okay.
28.
Yeah, why don't you?
This these things.
And how hard will
It's all they, four more.
Stop, we're just.
Cause I always get better.
Okay, the problem is that the time.
Have anything? You don't have.
Timekeeping and all
Yeah,
this.
zero out, those are the natural adults.
These are alcohol or.
Family members. No, yeah, I was gonna say,
I mean, do you wanna take 48 hours of time to have one of your
I
employees
think
use
that
it? That's my
once this
thing.
is there.
I need your payroll to pay stuff.
Right.
Depending on how many employees you have and how much they use.
Well, that's why I think
These things are.
we might be better at.
Mine is too, I always keep it on the phone.
That's all added on.
Hey, Houck.
Is it better?
The last name is my firm, partners at the time. Yeah, I'll get back to you. I'll look at it. Yeah. Yeah.
Then you're gonna pay for your.
Okay.
You just have to add.
Yeah.
Right, so for me, it's not,
We haven't.
ours starts after your first year.
There's somebody.
Right.
And I mean, that's like how I, or, I mean, it's not really anything. See, it's just, we don't give any.
I've done that.